Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Welcome to the Bottled Business Sense show. Today is Tuesday at 10 a.m. Looking forward to another great episode with our business followers out there. I am Rick Moscoso, one of your co-hosts today. And on the other side, waiting patiently, is my co-host, Mr. Bill Bernard. How are you doing today, Bill?
I'm doing just great, Rick. Summer's here. It's here hot and heavy, and it's hard pressed for me to believe that this great weather can keep up. But the pool is ready, and it's ready to go for the weekend that's coming up. And in the meantime, we're going to forge ahead with our show because we've got some great business tips in the area of marketing, in the area of trust and estate planning, in the area of employment law, and of course, in the area of asset protection. These are the free tips we bring you every week, and that's what our show is geared to, as you know. And it's there for the small business entrepreneur and his family, his or her family, to make sure that the business prospers and is safe and moves along in that glass bottle. I want to thank Steve Smith of Growth Source Coaching at the top of the show for the last 4 weeks of his input and his expertise in marketing, and allowing our viewers to listen to some real great advice. I thought it was a great month, Rick, and I think everybody who listened will surely profit from it.
Oh, absolutely. For those of you who didn't get a chance to tune in for the month of June with Steve Smith, it was really a information-packed month for us. He primarily spoke about personal development and how that affects the best practices in your business, things that you can key on, things that you can do to eliminate all the time drains that make you less effective out there. So for those of you that would love to go back, or if you want to replay these, they're always available on our website at bottledbusinesssenseshow.com, or you can hear the audio replay on blogtalkradio.com/Bottled Business Sense Show. And check out Steve Smith. He's a business coach here in Southern California. His company is Growth Source Coaching, and you can read all about him at growthsourcecoaching.com. All of his contact information is on his website, so please take a look. He's an excellent resource here for us, for the show, and we wanted to make him available to you, all of our viewers out there. So.
Absolutely, yeah. It was a great month. Well, we're here at the end of June, and this is our 13th month on the air, it coming to an end, and I've loved every minute of it. And I thought today what we would do is kind of tie in some business assets to the duties of a trustee for all those out there who have an estate plan and principally a living trust, because I think it's important to know what your trustee is obligated to do upon your death, because obviously you want your family protected from probate. You want your estate protected from intruding eyes. You want it to be private. And of course, you want those assets, especially your business assets, to be transferred without any issues. So this is a very confusing area for a lot of people. So I thought that we might go over these quickly. It won't be a horribly long show. It'll be relatively short, but at least somebody who has a pen and paper can take down these notes and maybe gain some real expertise, if you will, about what their trustee is supposed to do when they pass, and of course, maybe even spur them on to consider a trust if they don't have one, because maybe they've been fearful of how this all works upon their death.
So, Bill, just for the general public out there, just give us a general definition of what a trustee is and what their assignments are.
Yeah, a trustee has a fiduciary duty to the trustor, which is the creator of the trust, to carry out the trustor's wishes. Now, remember, a trustor is also referred to as a settlor or sometimes a grantor, but they all mean the same thing. The trustor, or the guy with the OR on the end, if you will, is the person who creates the trust. The trustee is the person who carries out the trustor's wishes upon death. Now, remember that many times a trustor and a trustee are the same person while that individual is alive. Sometimes while the trustor is alive, he has a different person who's the trustee. But most often, the trustor and the trustee are the same person. Upon the death of the trustor, the creator of the trust, a successor trustee who's named in the trust instrument takes over the duties of the trustee who has now passed, and that trustee, the successor trustee, is now supposed to carry out all of the wishes of the trust instrument. That's it in a nutshell. And the first and primary principal thing he or she is supposed to do is notify trust beneficiaries, that is, people that are going to inherit the estate pursuant to the terms of the trust, of the trust provisions, and give them some idea regarding the anticipated distribution date, when the distribution of the trust is going to take place. And pursuant to the California Probate Code, you're going to need to wait at least 120 days after the trustor dies, because there may be creditor claims against the trust estate. You need to give the creditors time to be able to stake their claims against the trust, provide the final bills and that sort of thing.
So the creditors take precedence even before the beneficiaries.
Yes. And all of that is addressed in the trust instrument, or should be. And after that occurs, the trustee then determines what assets are on hand and where they're located. For example, the bank accounts, the cash, the securities, the real estate, the vehicles, and of course, for our entrepreneurs out there, the business assets. Very important, because it doesn't much help you, doesn't necessarily hurt you to a great extent, but it doesn't help you to have a business and not have that business in your trust. Remember, unless it's an irrevocable trust, one you can't revoke, and here we're talking about a revocable trust, one you can revoke during the course of your lifetime. Unless it's an irrevocable trust, those assets of your business are not protected from lawsuit, but they are protected from the California probate courts and all the expense and time and effort that goes with probate. So you want to make sure the trustee's got a very strict duty to make sure he knows where all these assets are. And he needs to, Rick, hand in hand with that, he needs to determine what bills have to be paid and what funds are available, because like you just mentioned, those bills have to be paid before the beneficiaries are given their fair share. And that means that you have to be able to establish the value of all of these assets once you locate them, right? You have to know what the value of the stocks are, what the value of the bonds might be, or the mutual funds if you have investment accounts, what the value of the business is, and how do you determine that? Well, the easy answer is you have an appraisal done. Okay? So you can hire somebody and pay them out of the trust estate to complete these appraisals to make sure that the value is ascertained, so that value can properly be distributed. Because it may say in your trust you have X amount of bonds, or you have X amount of real estate, or you have X amount of mutual funds, but you want to know what the value of those funds are Not that it's going to change the numerical distribution to the beneficiaries. They get as many shares as they're supposed to get, but they're going to want to know, and they have a right to know, well, okay, what's the value of this?
Yeah, this is a very important part of the equation here. But who is that individual that you would hire to do the appraisal of your business?
An appraiser. You can hire an appraiser if it's real estate. Excuse me. Or you can hire a CPA if it's other types of assets.
Would this have to be an outside CPA than the one you already have, or what's the common practice there?
Well, when you say the one you already have, remember there may be more than one beneficiary. So in order to avoid the appearance of impropriety, you probably want to hire a third party who's not related. And when I say related, I mean doing business with, or maybe even actually related to one of the other beneficiaries. And that's usually the job of the trustees, the trustee in conjunction with the trustee's attorney, the estate's attorney. This is what we call, lawyers call trust administration. Trust administration comes into play when the trustor passes, and now it's time to administer the estate. And that's a very important responsibility for not only the attorney, but the trustee who works hand in hand with the attorney. Now, if it's a very small estate, you may not need to have an attorney be involved. But the one you would want to go to, if you do want to have an attorney involved, assuming he or she is still living, is probably the person who created the trust, because he or she knows the most about it. And you want to review the investment portfolios with the investment advisors who have those investment accounts. Make sure that all the I's are dotted, the T's are crossed. Make sure that everything is up to date in terms of what the trustee has been trading, because the trustee is going to leave an account. So let's say the trustee leaves account XYZ, and then he leaves an account ABC. Well, there may be different assets in that account. One might have mutual funds, one might have stocks and bonds, one might have other sort of tax liens or any other types of investments. So that investment advisor is going to be a key to providing information to the trustee, so the trustee knows exactly what's going to be distributed to the beneficiaries. Remember that there may be non-trust assets. There may be assets that weren't put in the trust. And now maybe those are going to have to be probated, but maybe because of the pour over will that's created with the trust estate documents, you can find something that can be submitted to the court by way of a very short pleading that allows that non-trust asset to pour over into the trust and become part of the trust estate in order to avoid probate.
So are you saying something like expensive jewelry or perhaps expensive watches in a safe deposit box or something like that?
Well, if you have something in a safe deposit box, certainly personal property will be should be taken care of within the trust. But if it's not, if it's some sort of unique tangible personal asset that wasn't specifically referred to in the trust, then of course that's the job of the trustee to locate that, because even if it doesn't become part of the trust estate, he wants to advise the beneficiaries, hey, we have this asset or group of assets out there, and it could pose a slight problem, but I want you to know it's out there because eventually you guys are going to be entitled to it in some way. Now, if it's a piece of real estate, and there's other types of real estate in the trust estate, that's a great example of when a pour over will can be used, where the trust attorney, performing his or her trust administration duties, files with the court, shows the pour over will in the trust document, and then hopefully that piece of property that was forgotten in terms of being put in the trust estate can now be added to the trust estate and avoid probate. And you'll note that whether or not probate of non-trust assets does occur is if it totals less than $100,000 in value, you don't need probate. So let's assume he finds this, the trustee finds trust assets, non-trust assets, locates these, has them appraised and finds that their value is under $100,000, no harm, no foul. Because if it's under 100,000, no need for probate in California. Okay.
Mm-hmm.
Now, what's confusing sometimes for people, Rick, and what's really important, and what is really a very, very distinguishing feature of a trustee, or in this case, a successor trustee, whatever the case may be, is to make sure, well, it has to be a successor trustee because it's a time of death. The affidavit of death needs to be filed along with a copy of the birth certificate. It has to be filed at the county, and that way everybody's on notice now that a death has occurred, the trustor has passed, and now by using those affidavit of death and death certificate, you can file a preliminary change of ownership form for any property that are to go to parents or children of the deceased trustor. Because remember, when this property is passed to you in the trust, yes, you avoid probate, but now you have to have it changed into the beneficiary's name. So you need to have that affidavit of death, you need to have the death certificate, and you need to have the preliminary change of ownership form to file with the county recorder's office and assessor, and you need to do that within 150 days of the death of the trustor. So another hot tip for our people out there who are following along and may want to know what exactly the trustee has to do, because you want to keep an eye on your trust. You may be the successor trustee, but if you're a beneficiary, you want to keep note of what this trustee is doing, because he owes a fiduciary duty to the estate, and you're the beneficiary of that estate, and you want to make sure he's doing his job correctly, because trustees have been known to be sued. Mm-hmm. This is not. I want to say it this way: it's a simplistic task if you take your job seriously. If you don't, it becomes convoluted and can get you into trouble. You need to read, and I always provide a sheet to my clients with respect to the duties of a trustee and what they need to be made aware of, because I always say, look, if you're going to be the trustee while you're alive, Mr. Trustor, fine. But if you're going to have successor trustees, which you should, who are going to step into your shoes as the trustee when you pass, you better have them read this, because if they don't want to accept these responsibilities, they better decline the job. And of course, I always want to have at least 3 successor trustees. One may die, one may just want to quit, one may become incapacitated. So you want to be able to provide for a scenario where the law of averages is going to give you a successor trustee of some sort at the time you pass.
Let me ask you something here before
Sure.
we go on. So a lot of this stuff seems to be assuming that there's distributions after the death of the trustor, right? What about in the situation where, let's say, I want to provide for my grandchild who was just born, and
Mm-hmm.
I pass, but I want to pass my rental properties all to that person. There's nothing wrong with doing that, right? I mean,
no, not at all. You mean, excuse me. You mean at the time you make the trust, the grandchildren obviously are minors, and you want to pass it to them when they're 21, but they may not be 21 by the time you die.
Right.
Okay. Well, then there's provisions easily inserted into the trust that can provide for that distribution upon the time they turn that age, and that trustee duty would be extended to that particular time. And again, remember, you have successor trustees, so if one passes, another one steps into the shoes to be able to provide. Again, this is all part of consulting with your lawyer, because if you're an aged elderly person and the trustees are also elderly, the successor trustees you're going to appoint in the trust instrument, and your grandchildren are very, very young, you want somebody who's going to be able to survive. So you want to be able to consult with an attorney and say, okay, what's the best route to go here in terms of providing successor trustees who are going to be around when my grandchildren are 21. The other way you could do it is to provide the parents with the assets, with the strict instructions that upon age 21, they need to give the or age 26. Some people even use a longer age because people are more mature. That's what I try to get my clients to say, hey, 26, 26 or so instead of 21. And then the parents can disperse those assets pursuant to the terms of the trust. So
let me ask you one more thing. This convolutes things a little bit, just so I can follow you. So we have this situation where you want to pass on these assets, let's say real estate assets, onto your grandkids. So in the meantime, after your passing, who would be assigned to controlling those assets to make sure that, I mean, it's not a guarantee, but let's say it's a successful, enterprise, and who would be in charge of that asset until it can be passed on to your heir?
Well, the successor trustee would make sure that the asset stays wherever it is until the time that it calls for distribution. So if it's a piece of property, it's not sold. If it's a bank account, it stays where it's supposed to stay and what in the bank it's in. If it's an investment account, it stays with Edward Jones or whatever other investment house might have custody of it. And make sure also that it's making money. There are many provisions in the trust that allows the trustee to make investments and to make sure that the trust is profitable, because that is one of the duties of the trustee. We don't talk about it too much in this show, because we're assuming there's going to be distribution by the successor trustee upon the death of the trustor. But if there's a situation where the trust does carry on, like in the scenario you presented, that successor trustee would have the same duties as the trustor had when he was also the trustee when he was alive, to make the trust profitable for the beneficiaries. Remember, the trustee must cancel all credit cards and close up all accounts. And I don't mean just cutting up the cards with the scissors. They got to go and they got to call and provide the necessary information so that these accounts can be closed, and verify and pay all debts of the deceased settlor, such as medical bills. Usually you wait about 60 days on the medical bills, because you have to, I just say, hey, wait 120 days, because by law you need to wait 120 days for creditors. I consider, in my book, medical bills creditors. So wait the 120 days and you're normally good to go, because sometimes these are insurance bills, and sometimes that takes a little bit longer to get the ball rolling. Remember, if there was some sort of Medi-Cal benefits that the deceased trustor was receiving, you have to notify Medi-Cal, the Director of Health Services in Sacramento, and submit a certified copy of the death certificate. Make sure that after the vehicles are transferred, that you cancel automobile insurance. I've seen situations where bills keep coming in the mail because they're not notified of the trustor's death, and lo and behold, there's an insurance bill coming in the mail. So you need to be aware that your trustee needs to be able to do that. And I want to keep running a thread throughout this show that it's very, very important to make sure that your business assets that are in the trust are accounted for by the trustee, are evaluated in terms of being appraised, especially if they involve shares of a corporation. And those are some hardcore responsibilities, because if you build up a business as a young entrepreneur for your whole life, you want to make sure that the value of that business then passes on to your heirs. It wouldn't make much sense to have a living trust and put all of your assets in there and leave your business out of it, because your business assets, if worth over $100,000, are going to have to be probated if they're not in the trust. So normally what a trustee does, or a successor trustee, Rick, is establish a tickler system as to, important dates like income, when income is supposed to be coming into the trust from a rental property, when certain tax returns are due. And remember, the total value of the trust and non-trust assets, together with all taxes owed on the estate, if any, must be paid within 9 months after the death of the settlor. So if there's any estate taxes owed, They have to be paid within 9 months. So it's up to that trustee to get to the CPA and make sure that these things are taken care of and arranged for within the 9-month period.
So the tickler file, is that a legal term, or is that
No, a tickler system is no. You ought to know better than that, my friend. That's Rick's attempt to be a little funny here, but no, it's a system just like any other system where you keep a calendar and you make sure you know what's going. When you are a trustee with those responsibilities, and it may already have been done for you by the trustor who may have also been the trustee while he was alive. That way, you've got everything and all your ducks in a row, and you've got everything calendared for what has to be done. So a real quick recap, because I know we're running up against the end of the show. Notify trust beneficiaries as required by law of what the value of the estate is and get all the assets appraised. You have to wait at least 120 days before distribution to allow for any creditor claims. Make sure that you work with a CPA if you need to, and make sure you file all taxes due on the estate within 9 months of the death of the trustor. If assets that are not in the trust are worth less than $100,000, you don't need to probate them. Record an affidavit of death with the county and a preliminary change of ownership, as well as a copy of the death certificate with the county recorder's office, so you can change property over into the names of the beneficiaries, and make sure that you follow through and ensure that all debts are paid, because all those debts need to be paid before distribution to the beneficiaries of the trust. Mm-hmm. So I hope that's been helpful, but I want to again emphasize your business assets, while not protected in an irrevocable trust, are protected hopefully by way of the business entity you've established, either an LLC or an S corporation. You put that business entity into your trust, and now your assets in that business entity are protected by the entity itself and are then passed without probate by way of the living trust. Now, there are other ways to give that business entity double protection if you put it in an irrevocable trust, but that's not the subject of our program today.
Yeah, it begs the question then. A lot of these are really good steps that a successor trustee should have or should be knowledgeable of. Obviously, there's some education that he'll have to go through with the attorney who set up the trust. But I would seem to think this person who these duties fall upon better have some knowledge in this area, at least some general knowledge, or can rely on the guidance of someone like yourself who has all these ducks in a row that can provide them with here's the list of things that you are responsible for that you need to be aware of.
Sure, Rick. Some trustees are very self-sufficient. Others need to work hand in hand with the trust attorney, who is now doing the trust administration of the estate. Yes, and that person will have all the answers. And there are some other things that trustee needs to do that, because of time limitations, I wanted to give the most important ones here today. But if you're working with that trust attorney who's administering the estate, you should have no problems. And if you just read the sheet that you're given, that I give all my clients at the time you become the trustee or the successor trustee, all of these things are there for you to read and ask questions about. They're easily understood if you do read them. And more importantly, they're there for you to read, because if you don't want to accept these responsibilities, then decline being a successor trustee.
Yeah. Well, fortunately for our viewers out there, we have the fortune of vetting an attorney that is an expert in this area, who also happens to be the co-host of the show, Mr. Bill Bernard. So for those of you that have any questions in regards to the trust or this type of area, Bill, what's the best way for somebody to get a hold of you to take this up further?
Well, the website, of course, www.wfblegalconsulting.com, which, by the way, has some resources, resource section where you can read about trusts, and also you can even watch the Bottle Business Sense show on my website, as well as on our own Bottle Business Sense show website. And you can get a hold of me at the following phone numbers: 949 area code for both, 413-6535, 413-6535, or 698-6222, 698-6222. I give free consultations, and I'm happy to answer any questions anyone might have.
Yeah, and Bill Bill provides a great resource in the Bottled Business newsletter. Or, I'm sorry, Bottled Business Sense newsletter, in various aspects of law. So, including our discussion today and other areas. So, check it out. I mean, there's a ton of resources in there, and Bill does a great job in informing the general public and his clients and the viewers of this show with all that information. So, check it out on wfblegalconsulting.com.
Appreciate it, Rick. The Bottle Business Sense newsletter is there, and of course, it too has its own site, www.bottlebusinesssense.com, as opposed to Bottle Business Sense Show. You just leave the show off, and you'll get the newsletter. You put the show on, and you come right to our show website. So there it is.
There you go. Well, thank you very much, Bill. That was a great show. Great overview for those of you that are interested in this topic. Again, we are the Bottle Business Sense Show. We're here every Tuesday at 10 a.m. And thanks again, Bill, for your time today. Reach out to Bill if you have any questions in regards to a trust or the duties of a successor trustee. He's available by phone or by email. Just a great resource to have. So thanks again, Bill, and look forward to seeing you again next week. Same time, same place.
Same here, Rick. And remember, everybody, as we leave, remember this is all about combining the safety of your business assets with your personal assets. So this is a very integrated format that we've tried to provide today to express the responsibilities and how seriously they should be taken. So again, thank you, Rick, for everything you do as well, and we'll see you all next week, same time, same place.
All right. See you next week, everyone. Have a good day.